Hi, everyone. We're going to give you just a minute to all get into the room and we'll start. Let's see more people coming in. This is great. Okay. All right, let's get started. Hi, everyone. Welcome to the seventh Covey Law and Thomas Dot Office Hours webinar. Office Hours is a monthly series, and each session focuses on one broad and timely topic related to U.S. immigration, with an emphasis on the cultural sector. My name is Amanda Gupta. I'm the head of the General Immigration team here at Covey Law. I am a white woman with long blondish hair, and I am wearing a black shirt. At Covey Law and Thomas Dot, we hold ourselves accountable to the work of undoing oppression and advancing equity. As part of this work, we must start by acknowledging that we're broadcasting today from the ancestral and unceded lands of the Lenape people. We pay respect to the Lenape elders, past, present, and future, the traditional custodians of the lands of which we convene today. So immigration obviously is complex. That's why you all are here. We can't hope to provide comprehensive coverage of any topic. So here's our disclaimer. The information that we provide today should not be taken as legal advice, which can only be given regarding the circumstances of a specific case. We will be giving you the best information that we have right now, and you should feel invited to reach out to us if you have specific questions that we haven't answered, or if you are making important decisions based on what is discussed here today. If you are watching this on video after June 10th, 2026, some information could be outdated by the time you hear it. So again, please reach out to us for updates. If you are a Covey Law client, feel free to reach out to your attorney or paralegal or case manager. If you are not, feel free to contact Thomas Dot's pro bono hotline, Thomas.avail, and I can place that information into the chat. We can get that into the chat for you. Okay. So in the next hour, you're going to hear a practical breakdown of the process for securing a green card from within the U.S. That process is called adjustment of status, including requirements, pros and cons, filing periods, and most recent policy changes. We'll cover the USCIS policy memo released on Friday, May 22nd, which has been extensively covered by the media and is creating a lot of confusion, uncertainty, and fear at the moment. I will be joined by my colleagues, attorney Kim Xavier and legal manager Davina Wells, and I will let them introduce themselves now.
Hi, I'm Kim Xavier, attorney at Covey Law. I'm a light-skinned woman with espresso and caramel long brown hair, wearing a beige blouse, a black blazer, and a light pink gold pendant.
Hi, I am Davina Wells. I am the senior legal manager at Covey Law, and I am a white woman with straight shoulder-length brown hair. I'm wearing a black shirt, a rusty-colored lacy cardigan, and a metallic glasses.
Amazing. Thank you, ladies. Okay, so again, just to recap, this is a 1 hour presentation on applying for the green card from within the US, the process of which is called adjustment of status. With the newest USCIS policy memo released just before the Memorial Day holiday, we decided that we would use this office hours to give a basic intro into the process of adjustment of status and explain the policy memo since it caused so much panic. So we're going to discuss the green card pursuant to the Immigration and Nationality Act, Section 245A today, specifically covering family and employment-based applications. This session is not going to cover processing outside of the US or securing green cards based on other eligibility, such as humanitarian or other special categories. We're not covering that today. We will leave time at the end for questions. And thank you to those who already submitted your questions with the registration. We will not be addressing specific individualistic scenarios For those, we recommend that you consult with an attorney directly. So we're going to start off with some definitions. Davina, can you kind of give us the baseline definitions that we need to be able to understand what we're talking about?
Absolutely. I'm also putting some of these definitions up on the screen right now so that you all can kind of refer back. There's a lot of definitions that we will be referring back to over the course of this webinar. So just as a very, very basic legal bases for processing, you'll hear these terms a lot. Statutes and statutory, they are the written regulations that are approved by Congress. Anytime we say something, a directive, procedure, or policy memos, those are USCIS's internal agency instructions that dictate how immigration officers are intended to interpret and apply those laws in daily practice. And then the eligibility path, Amanda covered a little bit already, but there are three main ways to go about getting a green card. There's employment-based options, which is the step one of an immigration petition that is completed, it's certified, approved. This covers things like PERM, EB1, EB2, etc. Family-based cases, these are I-130 form-based cases. They are either filed by a spouse, a parent, a sibling, or a child over the age of 21. Within that definition, there's also immediate relative. That is a term that is used a lot, and that is specifically related to US citizens as the sponsors. So someone as the spouse of a US citizen, a child who is under 18, whose parent is a US citizen, and or the parent of a US citizen child over 21. There are also other family-based priority categories, but we're not going to go into those in too much detail because they are very complex. And then the third category is other. This covers diversity visa lottery, asylum, refugee, VAWA, and a lot of others. There's a lot to cover, and we're not touching on today because they are a lot more complex. Then there are the two ways to actually request the green card itself once the eligibility is satisfied. And that is the adjustment of status process, which is the legal process that allows a foreign national who is already physically inside the United States to apply for lawful permanent residence, aka a green card, without having to return to their home country. The other option is called the immigrant visa process or consular processing. This is the second part of a two-step process where the first step is applied through USCIS, and then the second step is processed at an embassy abroad after the first step is approved. I will leave this up so that you can always refer back to these definitions for now.
Perfect. Thank you. Okay. And so as Davina just finished describing, the immigrant visa / consular processing part is what we are not going to be talking about today. But it's important for you to just understand the two different ways in which you can request and apply for the green card. So reverting back to adjustment of status, that is what we're going to be talking about today. I'm going to go through the statutory threshold that is needed for one to be baseline eligible to apply for the green card. So, one, you have to have approved eligibility, which, as Davina had mentioned, is employment-based. That is Form I-140, and that is for an artist going for an EB1, someone maybe who works in the public sector who's decided to go for an EB2, whether a national interest waiver or not. Or again, there's EB3, there's the PERM process that applies to some of those, lots of different ways, employment-based. The second eligibility would be family-based, which Davina also described. So you have to have an approved eligibility petition in order for USCIS to then consider the AOS process, right? And again, AOS, adjustment of status. So assuming that you have that, you also have to have been inspected upon admission. So it means you have to have entered the US properly. There has to be a visa available for you. So what that really means is an immigrant visa must be immediately available to the applicant at the time of filing. Now, what's interesting here is despite the fact that we just said we're not going to talk about immigrant visa consular processing, that it even though one is not going through that part of the process, right? We're talking about doing this within the US, it is still a baseline eligibility requirement that a visa has to be available in your category. Lastly, admissibility. This is that the applicant must be admissible to the United States for the purposes of permanent residence. So now that I've kind of given baseline eligibility here, Kim, can you talk about the bars? Let's talk about what makes you ineligible.
Okay. So again, under the statute that was implemented by Congress, these are regulations, it's written law. There are statutory bars to admissibility. Once you have the first part, the basis, the immigrant petition approved, that gives you the permission to go ahead and request to be a green card holder. Okay. So, in order to do that from within the US, to apply for adjustment of status, they look at certain inadmissibility factors. This could be triggered by prior status violations, immigration history, unauthorized employment, and even certain procedural like non-compliance. We're not going to go into each and every bar, but it's important to understand that if you have unlawful immigration status at the time of filing or fail to maintain your status since your last lawful entry, that's going to be an issue, okay, by the law, the statutory law. Unauthorized employment prior to filing. And these are general because the law also provides exceptions, which Amanda will be about to discuss with you. But I'm just telling you the general, the on its face, the big ticket items. If there have been any violation to the specific terms of your non-immigrant classification, if you entered as a visitor, if you entered as an F1, an H1B, an L1, any violation to the terms of that approved petition or that approved entry, that can be an area of inadmissibility. Okay. Another big one, and it doesn't apply to all adjustment filings, but it's public charge. If an applicant is deemed likely to become primarily dependent on the government for subsistence, and there are categories that are exempt, but family-based categories are not one of them. All the family-based categories require that you show you will not become a public charge and that the person or individual who sponsored you in the underlying and approved petition, or if it was concurrently filed, has to submit financial proof that they are willing to cover you financially should you ever need assistance. And when I say should you ever, there are also limits to that when that no longer applies. But for the purposes of our meeting today, I'm trying to stick to the overview. Medical grounds. This is a big one. They look at vaccinations. They look at substance abuse. A lot of questions I get are, I was charged with a DUI, but it was dismissed. That may not be an issue on criminal grounds, but the USCIS doctor is going to look into that from a medical perspective. So there are known infections that they test for, and there's a whole medical exam component for every single adjustment of status application. And lastly, I added in here criminal grounds. They also have exceptions for that, petty offense exceptions and different things, but they look at this closely. And these are all things that don't apply in that first stage when an employer or a family sponsor is saying, hey, we have a relationship with this person that would allow them to advance to green card. But once you get here, this is all fair game, and this is all going to be looked at. So now I will pass the mic back to Amanda for the statutory exemptions.
I was going to say that's a really great point, Kim, that it's important to understand you might be 100% eligible on the eligibility side of things on an I-140 or an I-130. And then when it gets down to the adjustment of status part, you hit a roadblock that you weren't expecting. So it is really important to ensure that you are considering and thinking through eligibility on both sides of it. Okay, so Kim just discussed the bars. I'm going to just kind of quickly go over some broad exemptions. Okay, so these are exemptions to the bars. So, and I say this as an attorney, of course, but this is one of the reasons why it is often important to talk to an attorney when you're thinking about going through this process, because your head might be spinning at this point that we've talked about what is the statutory eligibility here. Then we talked through bars to that eligibility, and now I'm about to give you exemptions. So so your head can spin sometimes when thinking through these things. So exemptions for employment-based applicants. There are exemptions for status violations under 180 days that were under 180 days. Okay, so it allows for adjustment of status despite previously working without authorization, failing to maintain continuous lawful status, or violating the terms of your admission for up to 180 days in total. So you have to make sure that it's in the aggregate, you're adding those up. Okay. Again, very good. If you think that potentially there's a reason that maybe you didn't exactly adhere to the terms of your work visa, it's really important, to be talking to someone to make sure that you're going through that to figure out whether or not you might be exempt from the bar. Exemptions for immediate relatives. So again, immediate relatives, that means a US citizen is sponsoring you as a relative. Okay. These individuals are explicitly exempt from bars, okay, to adjusting status based on visa overstays, unauthorized employment, and failing to maintain your lawful status. So that's huge, right? And again, that's a very important reason to make sure that you talk this out and you ensure that, if you think that you're eligible, but you may have some issues in your background, that, an attorney can help you figure these out and figure out whether or not you are in fact eligible and are likely to be successful on an adjustment of status application. So assuming, let's say that you have determined that you do think that you are eligible. Kim is now going to go through complicating factors. Okay, so these are just things also to consider. These are not necessarily deal breakers. They can be, but they're not necessarily deal breakers. But these are really important to consider.
Okay. And as a threshold matter, these are again statutory, established. This has always, even before this new AOS, confusing and misleading policy memo, many words we can use, came out. This was stuff that attorneys and applicants were already honing in on. Recently, I actually have come across some applicants who filed pro se, and these issues have cropped up at the interview or after. So one of the main ones is membership in Chinese Communist Party or any totalitarian party. You have to disclose this on the I-45. I will mention that the I-45 form is a very long form. It wasn't always that long, but it's about like 18, 20 pages plus, and there are a few pages where it's just a barrage of like 80 questions. Each question has a basis in law or precedent. So it's very careful to see how these questions are worded. But one is this: if you've had any membership in Chinese Communist Party or totalitarian party, it has to be disclosed. And this even includes childhood memberships, the
I was
Communist
going to
Youth
say,
League, or Young
I was going to say,
Pioneers.
Kim, yeah,
Yeah.
does it matter whether it was quote voluntary or not? What if the person says, but it was just automatic? I was not
It
actually.
has to be disclosed. So I like the way you just said that, like, does it matter? It matters for purposes of disclosing, because one of the biggest y- one of the things that can be most complicating for an AOS is if the officer determines that something you left out, if they consider it to be material or willful. So even if it wasn't willful, if they think it was material, and this is one of those categories, okay? What's interesting with this is that even if you belong to a youth league or a young league of any totalitarian party, whether we're talking about China, Russia, Afghanistan, North Korea, there are legal exceptions. And one of those is if you were under 16 at the time. So, for those who were still involved at 17 or 18, we have to look at this a little differently. But one clear exemption, and how I've dealt with this in many applications, is having a very detailed, like personal declaration, right? Um, Another way, Amanda, which you hinted at, is if it was involuntary or not meaningful to you. And the way that can manifest itself is sometimes if you work for a company that's owned by the government, your wages are going to be garnished. If you get a scholarship to a really good school run by the government, you have to be part of the party in order to use that scholarship to get that education. So this is recognized by law that, if it's involuntary, non-meaningful, or solely to obtain essentials of living, that will be exempted. You wouldn't need a waiver for that. And I think with the passing years, more and more people have decided if they want to abstain or leave the membership. But there once was a stigma, and there still can be in certain societal groups in certain towns. But if you can demonstrate that if it was a voluntary membership, it's one of those things that's a part of life for some people where they're growing up, that if it ended more than 5 years ago and you're not a security threat. So I've actually had each and every one of these exceptions come up, and you treat it a little differently, and it does come up at the interview. And if you don't have a personal declaration already, they will type something up and have you review it to sign it. So it's really important because this is something that you don't want to file your application and then think of this. And I'm going to keep going because another one, military service. You need to have the official discharge records. Those are required. There's specific countries that have mandatory conscription. You have to disclose this. If you've had weapons training, I had an applicant once who worked for TSA, and yes, they had to know how to defuse bombs and they had bomb training. So we put that on there. I had someone else who was part of a rifle association, purely for hunting, but you still disclose. And yes, I understand that's not military participation, but there are additional questions that go more in depth with things like this. So even if you weren't part of the military, but you got weapons training, or you were a corrections officers, we've had before too, this all has to be disclosed. And again, it's something that it's out there. It should not impact you. We give the officer the information and you're just prepared for it. Okay. Let me run through a few of these. Again, police records. Police incident reports is something that's coming up now. So even if you weren't arrested, and it didn't go forward, you need to be aware of that. One example that was brought to me recently was like the police was called and there was an incident report because I picked up the wrong gym bag at the gym and was accused of stealing that bag. Things like that, they seem benign. And if they're here in the US, it's easier to get the police incident report and things like that. And again, it's on a case by case basis. In addition to this, you want to consider traffic fines. The form specifically says that traffic tickets alone, if the fine was under $500 and it didn't have a controlled substance aspect to it, or a harm to property or person, that doesn't have to be included. But you have to look at that. I'm also now advising pull your driving record. Because yeah, a few traffic tickets is not going to be much, but if you've repeatedly driven without a license or insurance and have like 50 seatbelt tickets, that's something that shows recklessness. So, yes, traffic tickets alone, but they look at the whole picture here. So you have to be careful when you're answering these questions to really, really think about it, okay? Again, visa overstay, violations outside of the statutory exemptions we've already discussed. But here they're looking more at preconceived intent issues, like entering the US as a visitor and then immediately filing to change status. Or even as an F1, some attorneys do prefer to conservatively like get closer to the 90 days, even though that's a Department of State rule. It's not really, it hasn't been, it's not in the USCIS policy memo, it's not adopted policy, but they're looking at the intent. And when we get into the nitty gritty of what are some like things that we can foresee happening based on this policy memo, they're going to be asking more questions about surrounding factors. And why did you decide to come in as a visitor? And then when was it that you changed your mind? And we're going to deal with all that because this has been accepted. There are ways to file these cases. There's case law that the new policy memo ignores that we'll mention. So you wanna look at that. Really quickly, the last three that I have on here as complicating factors: medical history. I think this one seems to be overlooked often, at least when I first meet with people. Certain conditions, harmful behaviors, substance abuse. I've even seen asthma, diabetes, and high blood pressure listed as a Class B condition by the USCIS doctor. They do mention that this is controlled, like with medications and stuff like that. So it's not going to be a bar to the adjustment of status, but you have to think about these things with respect to the medical aspect here. And this
And
is
you know
one
what?
where
I was just thinking,
DUIs come in. Yes.
sorry, Kim, I was just going to say, you know what? One of the things that we didn't actually just state outright for everyone to understand. Whenever you're going through the green card process, whether you're doing adjustment of status or you were doing it through an embassy abroad, there has to be a medical exam. And so that is what Kim is talking about. You do have to go before a civil surgeon, which is a doctor certified by the federal government, and they are going to be the ones looking at these potential risks and or conditions.
Yeah, and there's specific doctors for the consulates, they call them panel physicians, and specific for USCIS. It has to be on their civil surgeon list. And they do take this form very seriously. For DUI arrests, while that may be not a big deal if it was a one-time thing, we can get around that. But some people don't realize that from a medical inadmissibility perspective, if they still think that that could cause reckless behavior or harm within the last year or within the next year, the doctor themselves can make a determination on that. So that's something you have to think about. And within this is also vaccinations. We all know it was very publicized that the COVID vaccine is no longer being required, but there are a bunch of other vaccinations that are required. And if you have a contraindication, if you've had an allergic reaction, that has to be documented by a doctor. And that wouldn't require a waiver as long as you bring that documentation and it's accepted by the civil surgeon. Okay. And one thing that comes up so much is like, okay, I had an allergic reaction to one, the flu vaccine. So I can't take any vaccinations. They don't all have the same components. They don't all share the same components. The amount of research, and I could talk on this for hours and hours, but I won't. It's on a vaccine by vaccine basis, unless you can establish a religious objection or a moral conviction, and that takes a lot of documentation to all vaccinations, not just one or the other. Okay. Another complicating factor, especially in family cases, more specifically, marriage, is repeat spousal green card sponsorships. If you, as a U.S. citizen, were married, already went through the green card process with your first spouse, and now you're doing it again, this is an obvious one. Stricter scrutiny on both the prior marriage and green card process and the current marriage and green card process is to be expected. And then the very last one, and I will be quiet for a little while, is public charge and the I-864. I mentioned public charge before, and it's this idea that you're going to be reliant on the government. Over the years and in the past Trump administration, they had tried to change what classifies for public charge. They now look at like totality of circumstances, your health, different things like that. Having Medicaid alone is not, we get questions constantly. Medicaid, Obamacare, is that okay? And it's strictly Medicaid for institutionalized care. Okay. And there are a few other things. But again, this is a case by case basis and something that you have to look at the law, the precedent, especially in your local office, and talk to the attorney that you've been working with on this. Okay. And basically, the I-864, it's an affidavit of support, but it's required for all family cases. And it's usually the sponsor who filed the underlying petition for you. And there has to be a financial threshold. They have to show that they make a certain income. Your income as the applicant, if you're in the US and have work authorization and it will continue from the same place, can be used. An income of a household member to the US sponsor can also be used. And you can get a joint sponsor who's a US citizen or a lawful permanent resident, not related to you, who maybe has W-2 income and is willing to sign one of these for you. Again, this could be its own office hour. So we're like running through this just so that you're aware. And I do have to mention, because some people don't realize that for employment-based cases, if it's a family-owned business that sponsored you, or you're related to the person who owns the business, so if the family has 5% or more ownership interest, or if it was a spouse, parent, child, or sibling that owns the business and was the signer on the I-140, an affidavit of support is also going to be required for your employment-based case. And I've also seen this. So all of this stuff does come up. It has come up. It's always come up. And it's something that we're just want to make sure we're looking at more vigilantly and making sure we share with our attorneys.
Awesome. Thank you for that. That was a lot to go through, and you did that as quickly as possible. Okay, Davina. Davina is just going to go over now the documentary, like and informational requirements, holistically, kind of what we're looking at for an adjustment application. Okay, let's see how quick you can get through these, Davina.
All right, so the documentary and information requirements, this is all also listed on USCIS's website. It's also on like the form instructions for the various forms. So this is easy to find and it's easy to get information on. But every application needs, well, not every application, almost every application needs all of these things. Everyone will need to have their original long form birth certificate that includes their parents' full names. This sometimes is hard to get. I know South Africa is about 6 months backlogged. This is a big one and one we run into issues getting all the time. So if you're looking to go for adjustment of status or apply for a green card in any way, make sure you have your original long form birth certificate in hand. If you are currently married, you'll also need your original marriage certificate. If you've been previously married, you need your previous divorce certificates. If you served in the military in any way, you need the military service documentation. You need police and traffic records and tickets. Also, this isn't necessary for submission, but for that medical exam that Kim has mentioned, you should get your vaccination records to prove what vaccines you've had already. That way you don't become a pincushion at the medical appointment. You need the medical exam completed by a registered civil surgeon. This isn't just any doctor. There's a list of doctors that USCIS provides. You can search for them in your neighborhood. It can't just be anybody. You will need to have a 5 full year history for both employment and residence. And you can't have gaps in that. You need to have 5 full years at the time you file. Um, you need information on any organizational memberships that you've been part of from anywhere in the world at any point in time. Um, it doesn't necessarily include gym memberships or museum memberships, but we have some clients that do provide that as well, just to be completely above board. Um, you will need to have your parents' biographic information. Some people who are estranged from their parents, this may not be easy to get, but you need to have as much as you can possibly get your hands on. Um, you will need to do an extensive background check. As Kim mentioned, there are pages and pages of background check information that spans your immigration history, your any criminal acts, national security, public charge financial information, and a whole lot more. Um, and then for the family-based cases and employment-based cases where the employer is partially owned by an immediate relative, which Kim went over with the financial obligations, um, if you need to file an I-864 with your case, then the U.S. citizen or lawful permanent resident sponsors information will need to be included, and that includes your 3 most recently filed tax returns, copies of your most recent IRS record of account transcript, all the W-2s and 1099s that you filed. You have to have confirmation of employment and your ongoing expected income for the year that you file. So you need to show that you actually are currently employed and will continue to be employed. And again, that's for the sponsor. Um, there's some additional stuff that may be required in very, very case-specific situations, but these are the basic requirements for all cases.
Amazing. Thank you. Okay, so the last thing we're going to get at here, generally in this process, before we start getting into the kind of government updates, policy memos, presidential proclamations, and all that good stuff that I'm sure everyone is interested in, is the work in the travel authorization, right? So I know some of you have asked questions about these, so a lot of you already know about these things, but Kim is going to go over them for those who don't fully understand, because there's a lot to understand here, so that once we get to discussing the policy memo and stuff, that we can better explain and that you will understand. So Kim, take it away.
Okay, so when it comes to work and travel authorization, when you file the adjustment application, which is Form I-45 in the US, you are allowed to file supplemental, what we call ancillary applications for a work permit, an open work permit, and travel authorization. Okay. And basically, those are incidental to your adjustment application being accepted and being pending. They process completely separately, have their own processing times, and are issued separately. We used to have the travel and the employment issued in a combo card, which was great. And once in a while, we'll get lucky, but more and more they've been issuing these separately. The thing with the employment and the work travel authorization to understand is that while you can file these and while they can be approved and you can get them, historically, at least in my practice, I have had clients have these as backups and recommended that they do not use them. The reason, unless they have to, the reason being is that when you use an EAD work card and your underlying status, whether it be H-1B tied to a direct employer, O-1 for multiple employers, F-1 student, or a B visitor, by using the EAD, you are no longer maintaining that status if, like for an H-1B, if you work for another employer that's not the H-1B employer. So technically, you then are in a period of authorized stay. You do not have an underlying status while your adjustment is pending. And when you get to that final interview, should anything go wrong, should the adjustment be denied, even for a technicality, you do not have the ability to remain in the US and change into another non-immigrant category like a dependent on your spouse. or to B visa or anything like that because you have no underlying status. So one of the most important takeaways here, and we're going to discuss it in conjunction with this new memo, is now more than ever, it is important to do whatever you can to maintain your underlying status, to renew your O1, your H1B, whatever it is, so that you have enough time before you apply for adjustment of status. They're all the only statuses, non-immigrant statuses that are considered dual intent are H and L visas. Even with those, if you decide to utilize the employment permit that you received based on your adjustment, you will not be maintaining those statuses. Okay. You can use it to work. It won't be count as unauthorized work because it's specifically authorized by USCIS. They gave you the card, but it does make things tricky should complications come up at the interview and should you not be able to ultimately adjust, because then you would have to pursue consular processing. So it's not without its risks and consequences. And again, this has to be viewed on a case by case basis, and they are personal decisions. Your attorney, as attorneys, we can give you the information, we can give our recommendation, but a lot of these decisions are up to the applicant and based on their specific situation, their goals, or their needs at the time. Okay. But we felt that it was really important to cover this and what it means to use that work permit. And also, if you use that work permit, you cannot leave the US without advance parole because since you don't, and this is more geared toward the H and L applicants who can sometimes get confused and be like, oh, well, I have my visa, but you use the EAD. So in order to come back in, you should come back in with the advanced parole. And we have clients who have stopped working for the H-1B employer. So there are situations where this can be tricky. Another thing is, even outside of the H&L context, at a certain point, your visa status, underlying visa status can expire, and you're allowed by law to remain in the US until your adjustment application there's a determination based on it, okay? But you do not have valid non-immigrant status. Where we've been seeing this creep up, historically, this was not an issue, but and there are more reports going on that if you go on a domestic flight and you go somewhere like Texas or any airport that has ICE presence, you can be questioned as to your status and action could be taken because you don't have valid status at the moment. So that's a big consideration. That's not something that we had been advising in the past. Status were able to lapse. This wasn't like a big deal. This is how we were used to immigration working. Now, this is an even more important consideration, and trying to maintain that status and just safeguard your own process is important. And there are considerations. I think that in some of these cases, it's going to be rare that you get stopped, but we have heard of it at certain airports in certain areas. Chicago, DC, I believe the San Diego area, or San Francisco, and things like this are happening. So this is another area where you need to, if you get it as backup, you need to think very carefully before you use it and consult with your attorney. Okay?
Awesome. Okay. So now we're going to give you a quick overview because we want to leave some time for Q&A of some of the more recent and relevant government agency actions that have happened. Okay. So I am first going to talk about the nationality-based pause that affected, when it was released, it ended up affecting people interviewing for visas or attempting to process green cards at U.S. embassies and consulates, and also the pause that happened with USCIS for those seeking green cards inside of the U.S. Okay, I'm going to cover that, and then Kim is going to cover the most recent policy memo in regards to the changes in discretion to adjustment of status cases. Okay, we're going to go over that because that's kind of the pertinent information that's the most timely right now. Then we will do our best to answer some questions. Okay, so let's talk first about this nationality-based pause. So, based on directives from a presidential proclamation issued in December 2025, effective January 21st, 2026, U.S. embassies and consulates abroad were instructed to halt visa issuance for nationals from 75 designated high-risk countries. This directive actually remains in place. Okay, this directive is still effective. But based on that same presidential proclamation, a USCIS policy memo was also issued, and that was issued January 1st, 2026. And it halted the final processing of most benefit applications in regards to adjustment of status inside of the U.S. So this is what a June 5th, just 5 days ago, a June 5th U.S. District Court struck down. Okay, so we're strictly talking about the pause within the United States for adjustment of status applications. Okay, so a U.S. District Court struck down and vacated the policy memo as unlawful, the one here in the U.S. Okay, but as I said, the policy in regards to U.S. embassies and consulates still holds. And that's kind of relevant for you to understand, because now Kim's going to talk about this most recent policy memo, on adjustment of status. So Kim, let's give them the kind of basics of that, and then we can try to answer as many questions as possible.
Perfect. So the USCIS new policy memo that was released the evening of Thursday, May 21st, right before the Memorial Holiday week, it set a new standard for discretion in adjustment cases. The administration's own rollout and the initial media coverage misunderstood and even misrepresented some of the details. So there was a lot of confusion surrounding this and surrounding the messaging, and there still are some lingering questions. But the administration actually rolled it back. They walked it back. Initially, it was billed as "No More Green Cards in the U.S.," which was a crazy title to see online or in print media. And then, oh no, we're going to give employment-based cases priority, and maybe only some people. And as more clarity has come, and we've really been able to dissect this, then the reason that we set up the our outline as we did was to really understand that nothing has changed with the law that allows you to file for adjustment of status here in the U.S. Congress made this law. They are the ones, discretion has always been a part of it. And very specifically, the statute itself states that any alien who has been lawfully admitted for temporary status, such status not being terminated, may apply for adjustment of status. The may is what gives the discretion and has always given the discretion for officers to consider these applications, especially if there are inadmissibility, national security, or other security risks, okay? But this memo decided to take that may and reinterpret it to require extraordinary discretion, which is not the case. It is not required in the law in any way. They also, the memo purported to say that by not that framing adjustment as the exception and consular processing as the way is backwards. It doesn't even, it's not, again, in the law, okay? The memo also ignores a very important precedent decision that basically says when there are no adverse factors, the application will ordinarily be granted, okay? Assuming you're statutorily eligible, which Amanda went through those basic statutory requirements, okay? You have an approved underlying petition, there's an immigrant visa available, and you are not required to affirmatively document any outstanding equities to win approval. Is if there are adverse factors. And one of the biggest problems with this memo is that it alluded that an adverse factor is you not pursuing consular processing, which has never existed and should still not exist. The key takeaways for this memo is that whether you provide additional documentation on any favorable equities, this is going to be a personal decision and on a case by case basis. If there are no adverse factors, you should not have to do it. But the goal, in my opinion, of this memo was to create fear and to deter people from pursuing more green cards in the US as planned and as they are allowed to do by law. So the damage was done with this memo because we don't know how it's going to be applied, which offices are going to be stricter. I think overall, I see this as narrowing scrutiny. Where there are any complicating factors, they're going to be looked on more harshly, and you need to be prepared. You need to prepare these conversations. The conversation about whether to consular process and adjustment of status has always been there in the context of going to the next step for the green card, but it's going to have to, I think, be done more carefully and with really, if you think it might be, just share it with your attorney or look into it because it can come up. What we've heard, so anecdotally, in the wake of all of this, adjustment of status cases are still being approved. Adjustment of status cases, even without interview, are still being approved. One development that was reported in certain offices and by many colleagues is that some officers are asking new questions. Okay. Some of these questions: why did you choose adjustment of status instead of consular processing? What other factors would prevent you from going through the consular process? To get at, like, why did this person choose adjustment? Whether these questions will continue to be asked and whether they'll come up for you or in an RFE, that remains unknown. This is evolving, but knowing that this is a possibility and preparing for these is key here, okay? It's important to prepare in case, for any reason, even outside of this memo, if it's based on a technicality, for any reason, your adjustment of status is denied and you have to consular process, and you haven't maintained an underlying status, you are going to have to leave the US to do that, okay? And another thing that's important to note is you choose on that underlying petition, that I-140 or I-130, whether you're going to apply to adjust status or whether you're going to consular process. That choice is made in that first form, okay? And it's a procedural policy that if you choose adjustment of status, your case file is then not sent to the National Visa Center, which processes all immigrant visas. So one thing, some attorneys, including our firm, we file at least our employment-based, our I-140s, saying consular process almost exclusively because it allows that process to be open should anything go wrong with the adjustment of status. If you only chose adjustment of status, you didn't choose consular processing, you filed your adjustment of status, you will need to file another form. It's an I-824. It's basically asking that your approval be sent to another office, which is the National Visa Center. This carries its own filing fee and could be upwards of like 12 months to process to start that with the National Visa Center. And once they create a case, you don't have to pursue the consular processing case. You just have to contact them within the year to make sure it stays open. And that's something, again, that it has to be a concerted effort with your attorney or counsel to see should you put that in as a backup? Do we file it now? Should anything go wrong? Some conservative applicants and conservative attorneys, that may be the approach. Here, again, it's individual, it's case by case. So the purpose of today was not to, make these decisions, but to let you know about them so that you can look into them. And I think we have some time left for questions.
Amazing. Cool. Okay. So, and if for those who are able to stay on a little bit longer, we can maybe go over a little bit and try to get to at least a couple of questions. I have been answering some of the questions in the Q&A myself. Again, if your question is super, super specific to your situation, we might not have time to answer those, because what we're going to try to do here is answer the questions that are as broad as can be, that apply to the most amount of people. So let's start with one that's very near and dear to us, that we answer a lot. I am on an O1 visa. I'm currently working on a green card application. Should I extend my O1 until the green card is approved? Our response to that as it stands right now, yes, absolutely. So this, and again, to Kim's exact point, this policy memo is so new. We are not 100% sure how things are going to be actually adjudicated in regards to each USCIS officer who is in front of someone, making a decision. But by far, the safest thing to be doing is to be maintaining your underlying non-immigrant visa status, right? Which in this situation is the O1 visa, right? Maintain that, continue to work pursuant to the way in which that O1 was filed for you. And if in fact your adjustment of status is still pending and your O1 is about to expire, we recommend renewing it. Okay, next. Let's see. This one actually should be quick, and this might answer for a couple of people who actually are already on a green card. But I've had a green card since I was 11. I had to apply for a replacement card this year. I've done this before, but this time it's taking longer. I'm not sure what I'm supposed to do. So let's just, Kim, can you just kind of quickly go over, like, one, what it is to file to renew the green card and what it means if in fact you need to travel?
Yes. So to file to renew or replace a green card, and there's a distinction there. So if your green card was expiring within 6 months and you filed to renew it, it's an I-90 form. You can do it easily online, and the receipt notice that you get back states on its face that it will serve to extend your expired green card, but you have to have that expired green card in hand. So together with the receipt notice and the expired green card, that is proof of your continuing status. Also, when a green card is expiring, the green card itself is only proof of your status. Your status doesn't go anywhere. So if it already expired and you're like, oh my God, I didn't renew it, that just means that you don't have valid proof that would be accepted for traveling back into the US or for a new job for the I-9 requirements, okay? So the key here is, if it was renewing, you have the expired green card, look at your receipt notice. I believe they've changed this to like 36 months or 48 months. It'll say on the receipt notice because it's taking a while. It was 24 months at one point, and I think they changed it to 36 months beyond the date of the expired green card. Now, if you don't have that expired green card, though, the receipt notice alone is not going to serve as proof of your green card status, and you have to request what's an I-551 stamp or ADIT stamp from like your local office. You can do this by setting up a USCIS account and saying that you want to request one of these stamps. What I've seen is that they used to make you go in and do one of these stamps, like to go in person, but they're processing these locally, and they'll actually use one of the old I-94 cards and put the stamp on that and mail it to you in most cases. Even if you're a conditional resident and for any reason they asked you to mail in the card, which is rare, but it can happen, if you don't have the physical expired green card and your receipt notice, you do have to get one of these stamps in advance, and you can do that through the USCIS online account.
Wonderful. Okay. Here's one that a lot of people are asking this in kind of sort of different ways. Okay. But and Kim, I'll let you answer this if you're okay with that. So I'll ask it, you answer it. So what if someone has a current green card pending, though, and they do in fact, and they're underlying, so sorry, let me back it up. They have an adjustment of status pending, right? Whether it's based on, let's say, an EB1 approval, or whether it's based on approval of an I-130 based on marriage to a U.S. citizen. But while the adjustment of status is pending, their underlying visa expires and they do not renew. What does this mean for them? Let's assume that they have an approved, they have the approved work authorization and they have an approved travel document. What does this mean for them?
Okay. First, it means they are in a period of authorized stay here. They don't have a valid underlying status. With a valid and issued advance parole document, the travel document, they can travel and request admission back into the US. In fact, even if your underlying status is still valid, even if you renew outside of the H and L classifications, if you're an O1 and your O1 is still good for 2.5 years, you cannot leave the United States with a pending adjustment without having advance parole in hand. You will abandon the application. So it's critical to have advance parole in hand for any status outside of H and L statuses. If they have a valid visa for H's and L's only, they could depart without abandoning. But everyone else cannot. You're basically landlocked until you get this advanced parole. And over the last few years, that has been a point of tension for our practice. Especially, we do a lot of O1 to AOS, and you cannot travel until you get this advanced parole, which makes it hard. And in some cases, that's why we decide to consular process from the beginning. And I think that there is this misconception. I want to mention it because Davina had mentioned it while we were in like pre-sessions, that some people think that because you consular process, you can't stay in the US. That's far from the truth. What consular process just means is that eventually, when your number's up, when the interview is there, you have to go abroad to do your medical exam and do your immigrant visa abroad, but you maintain your status here, and you can still come and go on your O1, or things like that. There are difficult situations coming in on like ESTA or a B visa. I have done that for applicants, but it's things that have to be looked at more closely. But aside from the advanced parole serves just as a visa. The advanced parole will serve as your documentary requirement to ask for readmission. The regular customs inspection they will look into see if any like criminal things have come up. Now they're looking into social media to see if there's anything that comes up about national threats. So you still have to go through the regular customs security processing, but the advance parole should serve as your documentary requirement to be allowed back in. Does that make sense?
Yeah, I think that that's super important. That's great. Okay, so I think again, let's just go over one more time to make sure everyone does understand, right? That if in fact you allow your underlying work visa status, right? Let's just say you're O1. If in fact you allow your O1 to expire while you are waiting for your green card to be approved, you are you're effectively changed from this, you're currently in, your O1 status to a period of authorized stay because the green card is pending for you. So
yeah, the technical terminology is AOS applicant.
I mean, right, that becomes your title.
pending.
You're no longer an
Yeah.
O1 holder. You're no longer an O1 individual of extraordinary ability. So, and the reason why we are at this time, and I do believe a lot of our colleagues in the immigration law field are advising clients not to let that happen, is simply because this new policy memo begins to talk about the things that the officer is going to be taking into consideration when they are adjudicating your AOS ultimately and at the interview, the things that they might ask you. They might want to know, why did you let it lapse? And so it's not that it's terrible and all of a sudden you have to leave. Like if your O1 expires, like, oh my goodness, you're just gonna have to go. That's not necessarily the case. And again, with your individual specific situation, you should of course talk to an attorney who can advise you on this specifically. It's just given this kind of shift to considering all the factors of your specific situation, it seems prudent to us to generally advise to stay on that work visa while the AOS is pending.
And even before this new policy memo, I would say, as of the inauguration, we began giving that advice because it's an extra layer of protection. It shows that you have a valid non-immigrant status. You have to carry your I-94 with you wherever you go as proof of your status. And without that, you have an I-485 receipt, basically. And this is your period of stay that proves it, but it's not a non-immigrant status. And that technical difference just becomes more prevalent if you're in like a border town or a port of entry where there is some ICE presence, because that can be seen differently and get you caught up. Okay. But again, it's also that layer of protection for should anything happen, should you not be able to proceed with the adjustment of status, should an emergency happen at home, the advance parole hasn't gotten here and you need to leave. There should be backups in place so that you can come back in, you could do the consular process. And that's kind of, it's just had us practice more conservatively, and certain gray areas or outside of the box thinking that were accepted and worked and we came to rely on is just no longer the case.
Amazing. Okay, 7 minutes over, but I think we got some good questions answered. I think that was great. Um, that concludes our presentation for today. Thank you all very, very much for listening. Thanks for all the good questions. Again, we tried our best to get to all of them. Feel free to email. Again, you can email Thomas Dot's pro bono line at thomas.avail if you think that it might be a question that Thomas Dot can answer for you. And otherwise, we would recommend at least seeking a consultation with an attorney if you're considering going this route, because it's really important. Okay, thanks everyone.